Hi, my name is Robert Chelle with Chelle Law, and my law firm assists physicians with employment contract issues. Today I'm going to talk about whether a physician can solicit patients after the contract ends. So this is going to be determined solely by the non-solicitation clause in the contract. Nearly every physician contract is going to have restrictive covenants, and these are things that the physician can't do either during and especially after the term of the contract. So once the relationship ends, either the physician terminates the contract or maybe the employer does as well. The restrictive covenants kick in, and then these state here are the things the physician cannot do after the contract ends. So what is a non-solicitation clause? Well, generally it means that the physician can't actively solicit patients, employees, business vendors, independent contractors for a period of time. So the period of time almost always is either 1 to 2 years. I mean, like 99% of physician contracts, it's probably going to be somewhere between 1 to 2 years for a non-solicitation clause. Now, the patient part of it will say the physician simply can't actively solicit patients. So let's say the physician leaves a practice and maybe moves somewhere else in the area. They will have likely a non-compete that will say to them, you can't work, for usually the non-solicit non-compete length are the same. So for 1 or 2 years within, 15 miles of your primary practice location. So let's say the physician leaves the employer, starts a practice outside of the 15 miles, and then says, all right, I'm going to download the patient list from the employer and then blast out an email that says, opening up my own practice. I want you to come with me. Here's my new address. Here's my phone number. That's what a non-solicitation clause would prohibit. The physician could not actively reach out to their patients, who they saw with that employer for that period of time. Now, what does the non-solicitation clause not stop a physician from doing? Well, a patient's healthcare provider is their choice. So an employer can't say, you are prohibited from providing care to this patient. It will, absolutely. I guess what I'm saying is the employer can't prohibit a patient from going somewhere, but they can prohibit the physician from reaching out. Now, if a patient reaches out to the physician and says, hey, I hear you're leaving. Where are you going? I'm interested in following you. I wouldn't consider that active solicitation on the part of the physician. They're simply answering a question, and then that should be okay. Now, some of the trickier stuff is, all right, what about like active marketing to a general public? Is a billboard considered soliciting? Is a Google ad? Is a website? Is a mailer? So these are kind of usually the intricate things that are the issues we deal with in a non-solicit. Most contracts will not define what is considered solicitation. So you just kind of have to say anecdotally, all right, well, would this be considered active solicitation or not? In my mind, general advertising should not be considered solicitation. You're not targeting a specific market. I mean, you are targeting a specific market, but you're not pinpoint targeting your patients from that employer. You're reaching out to the broad public. And so I would say that would not be active solicitation. So that's kind of non-solicit for patients. Now, employees, that can be different. If the employer is savvy, then they'll not only put you can't actively solicit employees, but they'll also say you can't hire them for that period of time. There's a big difference between you not soliciting an employee and then you not being able to hire them at all. Kind of a do not hire is enforceable. And I'd say it's probably maybe 25% of the contracts I review have a do not hire non-solicit versus a just you can't actively solicit them. I mean, the biggest concern of any, and this goes for mostly private practice, or I guess if you were like primary care for a big hospital network, is they don't want to bring a physician in. They establish a patient base, have relationships with the MAs, the nurses, the front office, whoever, office manager. Then they say, you know what, I'm leaving. I'm going to start my own practice. I'm going to take all my patients. I'm going to take all the employees. And then that employer is just kind of stuck. So that is the rationale behind these clauses. Are they enforceable? Yes, they are. They're generally reasonable if they're, as I said before, a year or two in length. And a employer absolutely can prohibit an employee from soliciting patients or employees. That's just, it's good business on the part of the employer. And honestly, it's fairly reasonable as well. So as I said before, kind of the biggest issue with this is what would be considered solicitation and what wouldn't. And then if the employee part of it says either you can't hire or you just can't solicit. So that's what a non-solicitation clause is in a physician contract. If you have any questions, you can always contact my firm at the phone number listed below in the description. Or you can always reach us through our website, ChelleLaw.com. That's CHELLE law.com. I appreciate you watching the video. Thanks.